Thank you, Cathaoirleach, and I move that the bill be read a second time. I am very pleased to bring the Criminal Justice Incitement to Violence or Hatred and Hate Offences Bill 2022 before the House. This is a significant bill that will update our existing legislation on incitement to hatred and will provide for hate crimes for the first time in Irish law. Development of this legislation has been long awaited, I think, by many, and is a key commitment in the programme for government. In introducing this bill, we will deliver on the following commitments. Firstly, to introduce hate crime legislation on an aggravated offences model and to create specific offences to ensure that those who target victims because of their association with a particular identity characteristic are identified as perpetrators of hate crime. And secondly, in order to ensure that those who seek to encourage and incite others to hate minority groups can be prosecuted, the Government will revise and update the Prohibition of Incitement to Hatred Act 1989, taking account of the public consultation which was conducted back in 2019. Members of minority and vulnerable communities have spoken time and time again about the horrendous and unacceptable prejudice, contempt and hostility that they face on a daily basis. They've been targeted, they've been subject to horrific abuse and attacks simply because of their identity. When we hear about these incidents, the victims are commended for their courage in speaking out and drawing attention to the discrimination and the hatred that they face. But this is no longer good enough. Giving people a pat on the back, these communities deserve to be protected, their identities and cultures celebrated, and to live without fear of victimisation simply because of who they are. Many individuals of our country live their lives hiding part of themselves, modifying their daily routines, changing the way they dress, the way they speak, the way they present themselves to the world, all in order to avoid being targeted. This is not the vision that I have for this country, nor I think many others. It is not the tolerant society that we want to live in. This new legislation will contribute in a very fundamental way to allowing everybody in Ireland to live without fear as they live the most authentic version of themselves. The Government's vision is of a safe, fair and inclusive Ireland, and we want to build stronger, safer communities. An inclusive Ireland is one where crimes motivated by prejudice, hate or bigotry are not tolerated and where everybody feels safe and is safe. We want perpetrators of this vile behaviour to know that they will be punished for spreading hate, for spreading prejudice and division. In developing this legislation, my department carried out an extensive public consultation process. This began in 2019. It comprised of surveys, stakeholder consultations, a call for detailed submissions and focused work groups. 7 independently facilitated discussion workshops took place right across the country. A series of meetings were held with interest groups, organisations, academics, law enforcement professionals and other experts. And I know that maybe today but also yesterday we had a number of representative groups against hate crime who have worked on this, and just to thank everybody who was engaged in getting the legislation to this point. This engagement resulted in vital insights from the communities and in particular the individuals most impacted by hate speech and by hate crime. The often moving and very distressing testimonies of individuals and groups recounting their lived experience of hostility and abuse provided the imperative to ensure that the new legislation would be victim-centred and effective. The findings of this public consultation process, along with analysis of qualitative data gathered in the stakeholder workshops and research by my department into hate legislation in other jurisdictions, all informed the report on the public consultation Legislating for Hate Speech and Hate Crime 2020, which was published in 2020. The conclusions drawn in this report underpin the legislation put before the Houses today and is grounded in the reality of what minority and vulnerable communities experience and need under the law. I'll turn to the bill itself now and just outline what is proposed. Part 1 of the bill is a standard part which gives the title of the bill and provides definitions for the many important terms used throughout the bill. This part also sets out the protected characteristics for the purpose of the bill, which are race, colour, nationality, religion, ethnic or national origin, descent, sexual orientation, gender, including gender expression or gender identity, sex characteristics and disability. These protected grounds have been expanded from those set out in the Prohibition of Incitement to Hatred Act 1989 and now include descent, gender, disability and sex characteristics. The protected characteristics represent those most frequently mentioned by individuals throughout the course of public consultation and in the submissions made to the Joint Justice Committee when conducting pre-legislative scrutiny in this legislation. The list of protected characteristics will be kept under review, and if evidence emerges of hate offences or hate speech targeting an identity characteristic not listed in the bill, then it may be added at a later date. This section will also repeal in its entirety the Prohibition of Incitement to Hatred Act 1989, which has been replaced by updated provisions that I will summarise shortly. This part also contains a standard commencement provision and standard expenses provisions. Part 2 of the bill is the part that deals with incitement to violence or hatred or hate speech. The principal purpose of this part is to provide for a new offence of incitement to violence or hatred, which will replace the provisions of the Prohibition of Incitement to Hatred Act of 1989. While in some respects the 1989 Act was ahead of its time 30 years ago, regrettably it has not been effective in the way we would hope in securing more than a few dozen convictions over the intervening period. As a consequence, I've directed that the incitement offences be updated to ensure that they are more effective, they are clearer and more reflective of the present-day context. The new legislation will lower the threshold for criminal incitement to violence or hatred to include recklessness, and in so doing will mean that prosecutions are more likely to be secured. This means that a person must either have deliberately set out to incite hatred or violence, or at the very least have considered whether what they were doing would incite hatred, concluded that it was significantly likely, and decided to go ahead anyway. This change from the 1989 Act to include recklessness was welcomed in submissions to the pre-legislative scrutiny process. It means that any intentional or reckless communication or behaviour that is likely to incite violence or hatred against a person or persons because they are associated with a protected characteristic, that it can be criminalised. The bill also provides for criminalisation of the condoning, denial or gross trivialisation of genocide and other crimes against humanity by creating a new offence as required under the European Council Framework Decision on combating certain forms and expressions of racism and xenophobia. A new separate and lesser offence of preparation or possession of material likely to incite violence or hatred has also been included in the bill, and this will include or apply to individuals who create hateful content with the intention of communicating it in order to incite violence or hatred, but have not yet communicated it publicly. I'm aware that there has been much attention and interest in how the right to freedom of expression is reflected in this legislation. This right is enshrined in our Constitution, it's enshrined in the European Convention on Human Rights. However, the right to free speech is not absolute, and limits may be placed on it by law to protect other fundamental rights. I am confident that this bill strikes the right balance in protecting freedom of expression with the rights of minority and vulnerable communities to be protected from hate speech. The bill expressly provides that a communication will not be taken to incite violence or hatred solely on the basis that it involves a discussion or criticism of matters relating to protected characteristics. I want to stress that this is not about enforcing politeness or political correctness. It's about providing protection to those who need it and those who currently experience extreme forms of criminal hate speech. While individuals can hold and express opinions which others might find shocking or offensive, I want to make it very clear that it is extreme forms of hate speech that deliberately and recklessly incite or stir up acts of hostility, discrimination or violence which will be criminalised. People may hold different views and opinions, but we're not here to criminalise those. People will not fall into being convicted of hate speech. There are defences available for reasonable and genuine contributions to literary, artistic, political, religious, scientific or academic discourse which are made in good faith. A reasonable and genuine contribution will have to be shown to be a contribution that is considered by a reasonable person, and this includes a judge or a jury, as being reasonably necessary in the context of a debate or a discussion involving a protected characteristic. We are all aware that online hate speech is an increasingly insidious problem with our current legislation, which is not equipped to deal with this. This is not surprising. The 1989 Act was not drafted with the online world that we live in today in mind. The new provisions of this bill will have been crafted carefully so that they operate effectively in both an online and an offline context. I want to acknowledge at this point the very important work of our colleague, the Minister Catherine Martin's department in this regard. The Online Safety Media Regulation Bill 2022, which is currently making its way through the Houses, will play a pivotal role in regulating and managing hate content online and will dovetail with the Incitement to Violence or Hatred and Hate Offences Bill of 2022. Through the Online Safety and Media Regulation Bill, an Online Safety Commissioner is being appointed to oversee development of legally binding online safety codes. These codes will govern the operations of social media companies, many of which do have headquarters here in Ireland, and will ensure that they take the appropriate action to promptly remove any hateful or otherwise clearly illegal content from their platforms. My officials have been working closely with officials from the Department of Tourism, Culture, Arts, Gaeltacht Sport and the media to ensure that the operation of these two important pieces of legislation is in tandem. Part 3 of the bill relates to hate crimes based on an aggravated offences model in line with the programme for government commitment. This model involves creating new hate crime offences where specific offences are aggravated by hate of a protected characteristic. The bill, as published, provides for 12 new specific hate offences. These are the most commonly cited crimes against people on identity grounds, and that's where they have been chosen. The aggravated offences will attract a higher penalty than the ordinary form of the offence, unless the ordinary form already attracts the maximum penalty possible. There is a safeguard included whereby if there is not sufficient evidence to convict a person of the hate crime version of the offence, they may still be convicted of the ordinary form. This is to encourage the prosecution of hate crimes and to avoid any risk that the entire prosecution will fail if the hate element cannot be proven. So if a person is assaulted, then there can still be a conviction of assault. A person is guilty of a hate aggravated offence under this part if they commit one of the core offences and in doing so are motivated by hatred of a protected characteristic, or that they demonstrate hatred based on a protected characteristic at the time of committing the offence. For all of the offences in this part, hatred may be based on the victim's actual or indeed the presumed membership of a group associated with a protected characteristic. As I alluded to, these offences include both a motivation test and a demonstration test as the test of proof. As initially drafted, the general scheme provided only for a motivation test for hate crime. However, in the course of drafting the bill, I think it became evident that a motivation test alone in providing hate offences sets too high a threshold and would likely be unsuccessful in securing convictions. Relevant stakeholders, including academics, those representing minority groups, advocated for inclusion of a demonstration test in their submission to the Joint Justice Committee during the pre-leg scrutiny process, and the committee subsequently included this as a key recommendation in the subsequent report. A demonstration test hinges on the perpetrator demonstrating hatred towards a member of a protected group or characteristic at the time of an offence being committed. This would involve, for example, the use of a hostile or prejudiced slurs, gestures, other symbols, graffiti at the time of the offending. The primary difference between a demonstrative model and a motivational model is that under a demonstration test, the prosecution must prove the demonstration of hostility, but no subjective intent or motivation is required. It is an objective test. Conversely, a motivation test requires proof of the defendant's subjective motivation for committing the offence, which indeed can mean a higher bar to secure conviction. Following the recommendation by the Justice Committee, my department carried out extensive additional research and consultation, including meetings with representatives from neighbouring jurisdictions in the UK, where the demonstration test has been in operation for many years with the AGS, DPP and the Attorney General. On the basis of further research and consideration, I made the decision to include the demonstration test in the legislation, firstly to ensure that it is necessary or successful in securing convictions where they are needed, and I'm pleased to note that this decision was represented by many of the groups that have been engaged with us. In concluding these opening remarks, I am absolutely certain that all sides of the House appreciate the need for this legislation and the positive impact that its enactment will have on the communities and the individuals most affected by hate speech and hate crime in our country. It will encourage victims, I believe, to come forward, to report hate-related incidents to An Garda Síochána. There are now over 350 Garda diversity officers trained, developed and supported to engage with and to attend the concerns of our minority, diverse and hard-to-reach communities right across the country, providing reassurance, building trust and extending the accessibility of the Garda service to these groups. In addition, the Garda National Diversity and Integration Unit monitors all incidents recorded on Pulse that have a discriminatory motive. They advise, they support and assist investigating Gardaí across the country who are investigating incidents which may have a discriminatory motive attached. Once enacted, the Criminal Justice Incitement to Violence or Hatred and Hate Offences Act would ensure that hate-motivated offences in our communities can be investigated and prosecuted as such. This, I believe, will help deliver a safe, fair and inclusive Ireland. I look forward to the contributions on this debate, and obviously we'll be happy to address any concerns, as I know there are questions still that people have and concerns around certain aspects of the bill. But really, the crux of this is making sure that people who currently live in this country, who do not feel safe, who do not go about their daily lives in the way that they should, that they will feel comfortable in coming forward where these types of incidents, where these acts of violence or incitement to hatred happen, that we support the Gardaí ensuring that there are criminal convictions, but that we very much protect individuals' right to free speech, that we do not stifle debate, but that there is a line and we need to make sure that where it is crossed, that we are very clear as a society that we will not tolerate it.